So thank you very much for being on the webinar, COVID-19, Your Legal Guide in a Time of Crisis, episode 1 with Allen Overy. We are very pleased to have a fantastic speaker and lawyer with us today, partner at Allen Overy, Mr. Jacques Graas. A few things about his background. Jacques is an experienced international M&A and corporate lawyer. Before joining Allen Overy in 2013, he worked for elite law firms in New York and in Paris. Jacques graduated from University Panthéon-Assas, where he's also lectured and holds a degree from Harvard Law School. Jacques, thank you very much for being with us today.
Thank you, Anthony, for the nice introduction, and hello, everybody. So this is also a first for me, a webinar with the LHoFT in these exceptional times, and I hope that you and all your loved ones stay safe. And as I mentioned, these are exceptional times. It's probably one of the biggest challenges for our generation, for social, political, business purposes. And of course, the law is in the center of all this. So it is also an exceptional time of legal challenges and disruption as regards legal aspects. And the purpose of this webinar really is to give you a sense of some of the key challenges that are, I believe, also relevant for most of you. And the way I want to structure this webinar is to really look at it from a company perspective and to divide it into two key parts. So the first part is about the internal situation of the company, and in particular the corporate governance and how decision-making can continue in these exceptional times. And then the second part will be more about the external contractual relationships and the different interactions that the company may have with third parties. So let's dig into the first part and with the focus on corporate governance. Let me first make a more general statement. In times of crisis, the most important thing is leadership. It's clear, transparent, and thoughtful leadership. And this is the same at company level, whether it's a very big company or a small startup. So the first really important element is that leaders and key stakeholders get together, determine a strategy to react in the short term, but also in the long term. If this has not been done so yet, getting together board of directors, board of managers, shareholder meetings, and really define that strategy. Make sure that the decision-making bodies of the company continue working in the same way. This is not only, to show leadership, but it's also to hedge any legal risk. Because leadership and directors or managers that do not react in these times, that do not paper what they are doing, may expose themselves to liability risks down the road, because we will be held, each of us will be held accountable for the way we act in this situation. So that's really the first point I want to make about corporate governance. Now, the second one is a more legal technical one. Indeed, it's easy to say, let's get all together and take decisions, but of course we are all confined at home and physical meetings are no longer possible. So how does that reflect into legal decision-making at the board and shareholder level? Well, fortunately, the Luxembourg government already reacted 2 weeks ago, so on 20th of March, an emergency regulation was taken that in short basically allows all companies, regardless of their status, regardless of their articles of association, to hold virtual meetings or meetings in writing. So from a legal perspective, a framework has been set that gives additional flexibility to those companies. Now, that's the legal framework. The other question is, how do you do it in practice? And the law, the regulation doesn't give you practical guides in that, so you are free to let your imagination flow. And for most companies, this is not necessarily a big issue, but imagine companies with a big number of shareholders and you want to organize a shareholder meeting. How can you make sure that you properly identify them? How can you make sure that there's not a fraud or a hack? How do you ensure confidentiality? So there's a number of practical issues that can arise. And by the way, for some of you, there might be business opportunities here, because the move from physical to virtual and from physical to digital is a move that, in my view, will stay. And in particular in the legal industry, and when it comes to legal decision making, there's still a very traditional point of view, and this will have to evolve. Just to give you another example, notaries. How do you hold a virtual meeting with a notary? There's still some obstacles also in the notarial law, and we have had certain discussions with notaries, but there's still practical uncertainties. So I mentioned the first point, just getting together, take action, define strategy. The second point about virtual meetings and this new framework. The third point I wanted to share with you in terms of corporate governance relates to the annual accounts approval process, and more generally the audit process. Normally, the calendar year is for companies that close their financial accounts on 31st December 2019. Well, normally annual accounts have to be approved by 30th of June and then need to be published within a month. And for some, this may become challenging because external service providers are not as reactive. Certain numbers may not be up to speed. And that's why the legislator is actually in the process of establishing a draft law that would extend this process by 3 months. So giving everybody a bit more time. The Luxembourg Trade and Commerce Register has already indicated that it will not penalize companies that are late in filing, and has extended the filing deadline until November. So that is good news in terms of being able to make these processes finish on time. So those were the key points on corporate governance I wanted to convey, and maybe I will stop here for a minute just to see if there are already any questions, Anthony.
Yes, Jacques. So we received a question from Gregory Kennedy from ThinSoft, and which is, how does e-signature play in this, and what is its validity?
Yeah, it's a very good question. It's also a very hot question that many clients are asking these days. Well, first of all, e-signature now is absolutely important. Even myself this morning, I signed an engagement letter with my finger on the iPad. Now the question is, what is the validity? By law, the law says that an electronic signature is equivalent to a handwritten wet signature. The problem is, what is the definition of electronic signature in the law? The way it is defined, it means that it has to be a so-called qualified electronic signature. And there's a European framework that defines what is qualified, what is not. And there's a bit of discussion to what extent certain providers provide that sort of qualified e-signature or not. The conservative view is to consider that in Luxembourg, it would only be the Lux Trust signature that would be qualified. That is the conservative view and the more, let's say, bad news. The good news is that even if you are not using that sort of qualified signature, your signature is still a valid means of evidence. And at the end of the day, the question of validity of a signature is not really the relevant one. The relevant question to ask is whether a signature provides sufficient proof of consent. And in commercial matters, that proof can be brought freely. So if you use DocuSign, or even if you sign on Adobe, in my view, in the vast majority of cases, that will be good enough. And at least as a law firm, we would consider that as a valid signature. Sometimes you may ask, to get an undertaking that a physical wet ink signature will be delivered subsequently. But overall, there should be some flexibility here. Okay. Well, I guess we can take the other questions at the end, just so to stick to timing as well. So let's move now to the second part, which is contractual relationships with third party in the broader sense. And in this part, I really want to talk about 4 different situations: M&A transactions, supplier-client agreements, lease agreements, and also financing arrangements. So to start with, let's talk about M&A transactions. The word M&A sometimes scares people because they think, okay, that's only very big bank merging with another very big bank. It's not relevant for me. But actually, the term M&A really encompasses all types of external transactions, be it acquisitions, disposals, even new investors coming in, shareholders agreements, investment agreements, all types of external transactions that are strategic for the company. And there are a number of situations that one can imagine. Imagine, for example, that you are in the process of raising new funds and you have a signed agreement with new investors, but you have not yet closed the investment round and you're between signing and closing. Because of the current situation, there could potentially be an argument for an investor to say, well, actually, I've changed my mind. I don't want to invest anymore. But unless there is a contractual clause that would clearly give an exit right, by law, there is no exit. There could also be a temptation that an investor could say, well, you know, I'm supposed to deliver certain physical documents. I'm supposed to deliver this and this, and we are supposed to meet according to the contract physically in your office to make the closing happen. Yes, that's true, and very likely it will not be possible to have that sort of physical meeting. That being said, there are alternatives. And in view of the good faith principle under Luxembourg law, I believe that it's very difficult for a party to try to get out of signed agreements unless there is a really specific clause that would allow so. And just to share some personal experience, over the last 2-3 weeks, we have continued closing very significant transactions, very challenging to get everything in place, but by relying on couriers and using offices as sort of intermediate places where documents can be deposited and picked up at a later point in time, there are solutions. That's the first situation when you are between signing and closing. Now, second situation I want to mention is the one where you have companies that see an opportunity in the current crisis. Because of course, it's a very significant, dramatic situation, but for some companies, this is also a business opportunity. You know, look at Zoom. You know, I wasn't using it before 2-3 weeks ago. Now I'm using it almost on a daily basis. My wife works at Amazon, and you know, Amazon, I can assume that the revenues and the demand is exploding these days. And for these companies, they may look at the market now and say, well, I want to acquire this or this target that is now maybe undervalued, or I'm in a better position. And if that's the case, you're of course free to do so. But what these companies will then really look out for is to include so-called material adverse effect clauses. And by the way, now we almost talk about Corona clauses, because the idea is to say, yes, they see opportunities, but the market is still so uncertain that you want to make sure that when you engage into a contractual relationship, you can still get out of it if the situation nevertheless completely changes again in a much more dramatic way. And so that is something to be kept in mind. The market is open, but there's a new environment out there, and there's new contractual clauses that we see as a result. So we talked about M&A transactions. Let me now move to commercial arrangements, and in particular arrangements with clients and suppliers. So many of you will have those type of relationships, either where you are on the client side yourself and you receive such supplies, or where you interact with counterparties that are buying services or goods from you. And again, in these exceptional circumstances, certain counterparties may see no longer a need to be bound by these agreements. And to take a very basic example, imagine you have an actual physical shop in Grande Rue, which is now closed for 1 month, 2 months, who knows, and you are expecting a major delivery of goods. You cannot do anything with it. You potentially cannot even receive it. And so there may be a discussion between parties to get out of contracts. And the key legal concept here is the concept of force majeure. So force majeure is a legal concept which is not clearly defined in the law, but which has been shaped by case law, and which basically says that if three conditions are met, a party can suspend contractual obligations. So these three conditions are: first, that the event at core is an exterior event. This means, for example, that a disease cannot be a force majeure. If I'm sick in itself, it is not a force majeure. However, the current situation, it's not just me, and I'm not sick for now, but it's just not me or somebody being sick, but there's a broader pandemic, and that pandemic is an exterior event. The second element is unpredictability. So it must be an event that could not reasonably have been foreseen. And this is an interesting criteria in this context, because if you look on the internet, and some of you may have seen also the TED talk from Bill Gates 4 or 5 years ago, of course, it was not completely unforeseeable that we would have this kind of situation. However, if you look at other people than Bill Gates and just normal commercial interaction, the extent of this pandemic is unforeseeable in my view. The third criteria is irresistible. So it must be an event that is irresistible and that makes it impossible for you to fulfill your contractual obligations. And that is really the most tricky part, because of course the pandemic as a whole is an irresistible event that is rolling over the world. But does it mean that we can no longer fulfill contractual obligations? Well, it depends. Again, if you have a shop in Grande Rue, you cannot open it. So clearly it is irresistible. If you are supposed to deliver goods to Italy tomorrow, it will not happen. But as a lawyer, can I fulfill my services? Yes. As a supermarket, can I continue buying stuff and selling stuff? Yes. So this is really something that needs to be analyzed on a case-by-case basis. And you can see that this will lead to many discussions and potential litigation. So we talked about M&A transactions, we talked about commercial relationships with suppliers, clients. The third part I want to tackle is financing arrangements. Many of you may have relationships, credit agreements with banks, loans that are outstanding. And one question is, of course, am I forced and obliged to continue paying interest under those loans? The unfortunate answer at this stage is yes. Legally, you are bound to continue paying those interests unless there's a very specific contractual clause, which would be rather exceptional. However, beyond the legal answer, there is let's say, a political / almost a moral answer, where, in particular in Luxembourg, certain banks have indicated that they will not enforce interest payments for the time being. There's even talk on higher political levels outside of Luxembourg to create a complete freeze of loan obligations, and certain countries have done so for consumer loans, for example. And more generally, banks are encouraged to not enforce covenants and to not push companies into defaults. But from a pure legal perspective, you are still bound by your contractual obligations at this point in time. That was about financing arrangements. The last bucket I wanted to tackle concerns lease agreements and relationships with landlords. And some of you may be landlords and then have the opposite view in terms of having the relationship with the tenants. And here, a similar question then for financing arrangement arises. Are you compelled to continue paying your rent? The legal situation here is a bit more tricky because fundamentally under the agreement, the short answer is yes. However, certain people from the legal community, and I personally don't believe this is a valid argument, but certain people believe that there is ground to argue that the rent payment is suspended if you can no longer use the premises for the purpose that they were rented for. Again, coming back to my example of the shop in Grande Rue, if I cannot use it, should I still pay rent? Legally, I believe that the answer is yes, you're bound to do so. And if you don't, there's a risk that you will expose yourself to litigation. That being said, beyond the legal perspective, here again, there is also a political perspective. And there are different incentives that are being thought through also in other countries to create certain freezes of rents, postponements of rent payments, to allow tenants to look through this crisis, which is fundamentally at this stage a liquidity crisis. And so the idea is to help them bridge. But you have to be extremely careful, because at this point in time, the legal environment in Luxembourg does not yet allow that. And with certain exceptions, such as the municipality of Esch, Luxembourg City, certain commercial centers, rent payments are still due. So this was the overview in terms of the third-party relationships. There's one important third-party relationship that I did not yet mention, which is employees. And generally speaking, all employment law impacts when it comes to short-term work, when it comes to special family leave, government subventions, etc. And my last sentence is really just a sneak preview then for next week, where my colleague Maurice Mackie will give you some insight on the employment law front. And in the meantime, I thank you very much for your attention, and I would be happy to take any questions. Over to you, Anthony.
Thank you very much, Jacques. So we have a couple of questions indeed. Let's start off with Bert Bowman.
Hi, Bert.
Are you there?
Yeah, I'm here. Can you hear me?
Yes, sir.
Okay, so a question maybe on the first topic that you covered, and thank you very much, by the way, for this session. Very helpful. So shareholders and board meetings in Luxembourg, they often happen physically in order to evidence substance from a legal and fiscal perspective. So now that these things can no longer happen in the presence of people, what kind of things can companies do in order to maintain a maximum level of substance?
Mm-hmm. Yeah, thank you, Bert. It's a very, very relevant question indeed. The unfortunate answer is that in the current circumstances, indeed, the physical meetings are not possible. Now, substance is, of course, an evolving matter. The fact that for 1, 2, 3 months, you are not able to hold physical meetings does not automatically mean that you will have a substance problem. But it could, of course, be an element where foreign tax administrations look at. That being said, it sounds, I don't believe that would be the case. The recommendation we have been giving to clients, and which I will give to you, is to really make sure that, one, this is properly documented in your minutes. So in the minutes, it should really clearly state that because of the COVID-19 pandemic, it's impossible for certain board members to come to Luxembourg. And that's why, because of these exceptional circumstances, you rely on the emergency regulation to hold the meeting, by phone or by video conference. That's one. And two, if you have people on the board that are from Luxembourg, at least you should make sure that these are the ones opening the meeting and are as much involved as possible. Now, if the situation was to continue, another more extreme measure would be to get additional people that are in Luxembourg on your board. But that is really, I would say, an extreme solution, and we would need to look at if in 3, 4, 5 months the situation is the same. But that I personally don't believe we will get into that stage, and the tax authorities need to show some flexibility, because substance also needs to be interpreted based on what is happening.
Thank you very much. Am I still unmuted?
No, please go ahead, Bert.
Okay, yeah, so if I may ask another question, I don't want to hold up other people's questions as well, but so for the shareholders meeting, so one of the things that was indicated is that it's very important to identify and authenticate your shareholders. So when you have no physical means to do so. If shareholders log into a like a system or a portal with a secure access, would that be sufficient authentication of a shareholder that you can then rely on their votes, or is there still exchange of documents with signatures required?
Well, the law doesn't give any indication on this. So unfortunately, this at the end of the day becomes a question of liability for the board and the bureau that will organize the shareholder meeting. So the board has a responsibility to make sure that the meeting is organized in a way that is sufficiently secure and allows identification. I don't think that there's a need for physical transmission of documents. You could. It all depends on your shareholder community. You know, we are helping, for example, to give you the extreme example of listed companies. And in listed companies, what we have done, what is the general recommendation, is to force people to vote by correspondence and to use intermediary banks and ask intermediary banks to confirm the identification. And that is, you know, the most complex scenario. Now, imagine you are a startup and you have 50 shareholders. How can you ensure the proper identification if you don't know them? You could ask a certain number of documents, you know, passport, a share certificate, ask them to scan it, send it over, sign it, and then you need to rely on that. There is no perfect solution, unfortunately, in this situation.
Okay, thank you so much.
Take care, Bert.
Very good. Let's take a question from Adrien Rollet. Adrien, are you there? Adrien?
Yes, you can hear me?
Yes.
I can hear you, but not see you.
Yes. Please go ahead.
Good morning. Yes, so the questions was really similar to the one of Bert. It was about substance and having all those board meetings and general meetings not physically held in Luxembourg because of course in our businesses, corporate services businesses, we have plenty of such meetings coming ahead, and of course most of the representative of all those pension funds or whatever funds or even, let's say, more basic corporate entities will not be able to physically come in Luxembourg as usually this is the case. So it was a similar questions. What about substance, which is of course today is of importance when we look at the worldwide environment. But I think, Jacques, yes, you answered already. Yes.
Yeah, absolutely. And hi, Adrien. Good to hear you. Yeah, indeed, it is a problem. Unfortunately, and as you know, the substance requirement is mainly a requirement driven by foreign tax administrations, and depending on the country that you're interacting with, the reaction may be different. You can imagine certain countries that are less concerned by the current crisis and would see it as an opportunity to be very aggressive. Unfortunately, beyond the solutions that are laid out before, we cannot, you know, it's somebody who's not physically here and cannot be here, that cannot be changed. So the most radical solution would be to change the board to people that are residents in Luxembourg.
Okay. Many thanks, Jacques and Anthony.
Thank you.
Thank you.
We have a question from, let's take a last question because we're running out of time, from Alex Panican. So his question is, how do you cancel a contract with an outsourcing company because of force? Just sending an email? What would be the right way?
Well, first of all, as I said during the presentation, there's no automatic cancellation right. You really need to establish how the force majeure affects specifically your contract. And then you need to look at the clauses of the contract, what they say potentially about force majeure and more generally about termination, and also about notices. And so my recommendation, if you believe that a force majeure event is characterized that renders your ability to fulfill your contractual obligations impossible, then indeed you should set that out in a written form, email or letter, depending on what the contract says. That being said, it is a very complex legal matter, and you may also want to get some upfront legal advice in that regard.
Thank you very much. I also want to thank Natasha Oskian from Allen Overy for agreeing to support us on this initiative. And before closing the session, I also would like to say that next week, for the second episode, we host Maurice Majeure, who's a senior associate of Allen Overy, and he will be discussing the rights and obligations of the employer in Luxembourg in regard of COVID-19. So stay tuned and see you next week. Thank you very much, and thank you, Jacques.
Thank you. Stay safe.